Welcome all to today's session on Public International Law. This is Dr. K. Sangeeta. Today we will see SS Lotus case. When you see the background of it, on January 4th, 1927, by the diplomatic representative at The Hague of the French and the Turkish government, the latter had submitted to the Permanent Court of International Justice the question of jurisdiction which has arisen between two states following the collision between which occurred on August 2nd, 1926 between the steamships which is Lotus and Boscott. Here if you see the case, France protested the act of the Turkish government and stated the following case. Under the convention representing conditions of residence and business, the jurisdiction signed at Lausanne on July 24, 1923, the principles of international law, jurisdiction to entertain criminal proceedings against the officers of the watch of the French ship in connection with the collision which occurred on the high seas between the vessel with the Turkish ship belonging exclusively to the French courts. The Turkish government on its part simply asked the court in its case to give judgment in favor of the jurisdiction of Turkish courts. Here the French government responded against in its case and formulated the conclusion in a slightly modified form, introducing certain new points. The new arguments and conclusions are as follows. Furthermore, whereas according to the international law established by the practice of civilized nations in their relations with each other, the state is not entitled, apart from express or implicit special agreements, to extend the criminal jurisdiction of its courts to indicate a crime of offense committed by a foreigner abroad solely in consequence of the fact that one of its nationals has been victim of the crime or an offense. Second, whereas acts performed on the high seas on board a merchant ship are amenable only to the jurisdiction of the courts of the state whose flags is there in the vessel, as according to the existing law, the nationality of the victim is not a sufficient ground to override this rule, and seeing that this was held that in this case of the Costa Rica Pact, the court decided that Turkey did have authority to arrest French officer under the Treaty of Lausanne 1923. The Permanent Court of International Justice held that offence produced its effects on the Turkish vessel, consequently in the place assimilated to Turkish territory, in which the application of the Turkish criminal law cannot be challenged, even in regard to offences committed there by a foreigner. Turkey has jurisdiction over the case. The principles of Lotus case. According to para 45, the court's decision states that the jurisdiction of the territorial where a state cannot exercise its jurisdiction outside its territory unless an international treaty or customary law permits it to do so. This is what we call it as the first principle in Lotus case. Now the first and the foremost restriction imposed by international law upon the state is that following the existence of the permissible rule of to the contrary, it may not exercise its power in any form in the territory of another state. In this sense, jurisdiction is certainly territorial. It cannot be exercised by the state outside its territorial except by virtue of a permissible rule derived from the international custom or from a convention. The second principle of Lotus case, within its territory, a state may exercise its jurisdiction on any of the matters even if it is no specific rule of international law permitting it to do so. In these instances, states have a wide measure of discretion which is only limited by the prohibitive rule of international law. It does not, however, follow that international law prohibits a state from exercising jurisdiction in its own territory in respect to any case which relates to acts which have taken place abroad and in which it cannot rely on some permissible rule of international law. Such a view would only be tenable if the international law contained a general prohibition to state to extend the application of their laws and jurisdiction of their courts to persons, property and acts outside their territory, and if it is as an exception to this general prohibition. It allowed states to do so in certain specific cases. But this is certainly not the case under international law as it stands at present. Far from laying down the general prohibition to the effect that states may not exceed the application of their laws and their jurisdiction of their courts to persons, property, and acts outside their territory, it leaves them in the respect a wide measure of discretion, which is only limited in certain cases by the prohibitive rules. As regards to other cases, every state remains free to adopt the principles which it regards as the best and most suitable according to the circumstance. This discretion left to states by international law explains great variety of rules which they have been able to adopt without objection or complaints on the part of the other state. In these circumstances, all that can be required of the state is that it should not overstep the limits of the international law, places upon its jurisdiction, or within its limits. Its title to exercise jurisdiction rests only in the sovereignty. When you see the issues, one can understand. Issue 1. Whether a state opposing the jurisdiction provide the absence of customary law that permits jurisdiction. When you see Rule 1, because all the acts that are expressly forbidden under international law are permitted by the practice, it is on the state opposing an act to show that there is a rule or a custom that does not allow such an act to be exercised. Issue 2. Does customary abstention of state from certain action create an obligation under the customary law to continue to refrain from committing those acts? According to Rule 2, most states have abstained from certain actions in particular circumstances, and it does not prove that they are obliged to do so, only that they have chosen to do so. So one should understand what the sovereign decides becomes the final verdict.